Hey folks, today I want to tell you about some of the important considerations in the Families First Coronavirus Response Act that was passed by Congress recently and signed into law by the President on March 18th of 2020. There's some interesting stuff in here for employees, some stuff that's going to provide a lot of relief to people over the course of the next 9 months or so. I, like a lot of you, are probably on home lockdown or telecommuting, teleworking. And so if you hear a baby crying in the background, that's a similar experience to what a lot of you are having. The FFCRA, the Families First Coronavirus Response Act, is an extension of the Family and Medical Leave Act for people who are experiencing the impact of the coronavirus. One of the changes to the Family and Medical Leave Act, it is now available for those who are most directly impacted by the coronavirus and COVID-19. And so a new section has been added to the Family and Medical Leave Act that's going to take effect on April 2 of this year and end at the end of this year unless they decide to extend it or otherwise modify it. So none of this takes effect until April 2nd of 2020. So first of all, one of the things that they changed, I'm going to read directly from the text. During the period beginning on the date of the Emergency Family and Medical Leave Expansion Act, so that's April 2, when that takes effect, and ending on December 31st, 2020, because of a qualifying need related to a public health emergency in accordance with Section 110. This is basically saying that people who need FMLA because of COVID-19 and the coronavirus. So all of those folks are now eligible for FMLA leave. Except it's a little bit different because the FFCRA modified which employers are covered by the FMLA with respect to COVID-19 and the coronavirus. Whereas an employer used to have 50 or more employees within a 75-mile radius in order to be covered by the FMLA, now they have to have fewer than 500 employees in order to be covered by the coronavirus portions of the FMLA. Employers that are fewer than 500 are now impacted and have to offer not just family medical leave for those who are experiencing coronavirus or COVID-19, but now employers smaller than 50 may have to offer that family medical leave. Another really interesting wrinkle in all of this is that employers are now required to offer paid family medical leave for those who are on family medical leave because of the coronavirus. And so the way that this works under the modified version of the FMLA now is that there is no payment for the first 10 days of family medical leave for coronavirus. Starting on the 11th day of your leave, you are eligible for up to $200 a day of paid family medical leave, up to a grand total of $10,000, so that comes out to 50 days. One of the other great parts about the FFCRA, the Families First Coronavirus Response Act, is that there is now required sick pay if you work for a qualifying employer. Fewer than 500 employees, you are eligible for up to 2 weeks, up to 80 total hours of sick pay if you are missing work because of coronavirus or because your kids are out of school because of the coronavirus and you have to be home to care for them. If you are missing work because of that, you are eligible for up to $510 a day or a grand total of $5,110 of sick pay from your employer. Where the modifications to the FMLA didn't start requiring that you be paid until day 10, you now have this sick pay requirement that's actually even better than the pay requirements for paid leave under the modified FMLA. One of the greatest things about all of this is that it incorporates the protections of the Fair Labor Standards Act. A lot of this is legalese. If your employer fails to pay you the required sick leave pay, it is violating the minimum wage provisions of the Fair Labor Standards Act, which triggers the protections of the Fair Labor Standards Act, which means that you can sue your employer for unpaid wages, and that employer could be liable for not just your sick pay, but liquidated damages in an equal amount on top of that, effectively doubling that amount to over $10,000, plus be liable for your attorney's fees. One of the great things about the incorporation of the FLSA into this is that you're protected by federal law from retaliation. If you work for a company that has fewer than 500 employees and you tell your employer that you need sick pay and your employer says, "That's stupid, I'm not doing that," you're fired. You are protected by federal law. You're entitled to reinstatement. You've got a valid legal claim for reinstatement there. Just like if you file a lawsuit for not getting paid your sick pay and your employer fires you for filing that lawsuit, you're entitled to reinstatement to that position because that employer has illegally retaliated. We're very early into this thing. This act was just signed by the president. A lot of new information is going to develop. One of the important things that might develop over time here is that there's room here for the Secretary of Labor to exempt certain employers of 50 or fewer employees. It's going to take a while for that to happen probably, but if that happens, we're going to see a band of employers between 50 and 500 who are going to be most directly impacted by this act. It does not cover employers of 500 or more people. Why? I'm not exactly sure. Only employers with fewer than 500 employees are covered by this. Also, one of the interesting quirks about this is just like other labor law posters around your workplace, your employer is required to post a poster telling you about these rights. The reason that we put those posters out there is so that people know about their rights and know that their rights are protected. So if you have any questions about this, like I said, this is all developing. It just happened yesterday, so we're going to learn a lot more about it as we can probe into it a little bit more and see how employers are going to respond to it. But hold your employers accountable to this. They are responsible for following the law. These are legal requirements. They're not allowed to ignore them. And so hold your employers accountable to this.